Picture this. It's 11:47 p.m. A text lights up. We need to talk. There might be doubt about the baby. Your stomach drops. You don't sleep. You start making lists in your head. What do I do first?
Welcome to Danny's Den. Let's chat.
In the next 10 minutes, I'll give you clear, practical steps. Legal basics you can understand. Specific first actions to protect your child and your rights. Scripts for talking to kids. And a couple of things to keep your weekend routine steady while you sort this out. Okay, legal basics, plain and short. In many places, marriage creates a presumption. The spouse is treated as the parent. Outside marriage, other paperwork matters, birth certificates and signed acknowledgments. A voluntary acknowledgement is that simple form people sign at the hospital. It's easy to sign, and that's why it matters. Undoing it usually means going back to court, and often to DNA testing.
A court can also order genetic testing when there's a dispute or when someone asks the court to determine parentage. That testing answers biological questions with a high degree of certainty. And yes, I know that sounds clinical, but I promise there are human steps you can take right now.
Look, DNA doesn't automatically decide custody. Courts, when they make custody decisions, focus on the child's best interest, who provides stability, emotional bonds, daily routines, school and medical care. Sometimes biology matters a lot. Sometimes the existing relationship matters more.
First practical step. Breathe. Then start a dated digital folder now. Screenshots of texts with timestamps, copies of emails, bank records showing transfers, and photos of any relevant documents. Put notes in the folder. Who was present, when, and what happened. That small file becomes a clear timeline you or your lawyer can use.
Also, ask an attorney about any deadlines or time limits that apply in your state as soon as you can. Some time limits start running quickly, right?
If you can, get a short consult with a family lawyer. If private counsel isn't affordable, check local legal aid, law school clinics, or community centers. They often handle basic questions at low or no cost.
If a DNA test is on the table, consent speeds things up and keeps tension lower. If someone refuses, you can sometimes ask a court to compel testing. But remember, testing answers biology. It doesn't automatically erase the reality of who's been parenting and who the child relies on.
Temporary orders are common while matters move through court. Courts try to reduce disruption, not amplify it. So sudden, complete removals are rare. Instead, judges often use temporary plans to keep the child stable. And judges notice that continuity.
For little kids, I love you. Some adults are answering grown-up questions, and I'm here with you. For school-age kids, we're figuring out some questions about our family. You didn't do anything wrong, and I'll tell you what we need you to know. For teens, there are adult things being sorted out. I'll share what you need to know and protect your privacy.
With the other parent, aim to keep communication factual and calm. Texts and emails create a record, but tone matters. Compassion and clarity go farther than accusations. If you're worried about escalation, use short, direct messages and note dates. Your lawyer can advise on what to send or avoid.
Protecting routines is huge. Keep movie nights, bedtime rituals, and yes, game days as steady as you can. Those small anchors give kids emotional safety while adults sort paperwork. Here's a short story. I once worked with a parent who feared paternity questions would erase every Sunday ritual. They were an Eagles fan. Pancakes, same jersey, a little walk if it was nice. We prioritized those routines. Those weekends became clear evidence of involvement and bonding, and that matters in court too. On money and decision-making, being a legal parent can create obligations like child support, but it also gives you a voice on medical and educational decisions. If parentage changes later, courts can revisit support and rights, but again, the child's stability and who provided care day to day will be central.
Quick practical tip. Make a one-page routine checklist. Who makes breakfast, who does bedtime, weekend rituals, school pickup. Dates and simple notes help you tell a clear story if you need to show involvement.
If you feel overwhelmed, reach out to a local family counselor
or parenting support line. You don't have to carry this alone.
For the music moment, when conversations are heavy, a short playlist can help reset emotions. Think gentle R&B/90s, soft Mary J. Blige, a slow Boys to Men tune. Familiar, calming, not too intrusive. Play it on the drive home after a meeting or during a quiet craft with your child.
Quick recap. Protect evidence with a dated folder and notes. Get legal input early and ask about any deadlines in your state. Keep routines for the child. Use age-appropriate language with kids. And remember, courts focus on the child's best interest, not only biology.
If you're dealing with this right now and want help figuring out next steps, I offer a free 30-minute legal consultation to see whether I can help. Send me a direct message or email me at danielle@thelegalassistancecenter.net.
If this episode helped even a little, please subscribe to Danny's Den for more practical, legal, and parenting guidance. Let's keep the conversation going. Let's chat. Thanks for listening to Danny's Den. You can also drop a comment below if you have a topic you want me to cover.